is interpreted by the powers that be at the whim of the moment. So if the guy in the town, the guys in the town of selectmen say, we're going to do a home-based business, and this is what we allow and don't allow, the court's going with them, and that's the way it is. The court's very rarely going to let the townspeople get away with telling the selectmen where it's at. However, cottage industry says goods or services much broader than home-based business, which allows people much more leeway on what they do in their property. Now, I spoke to them. My attorney told me this. I'm not pulling this out of the sky. You met him. Most of you did that were here at the meeting when we fought Happy's firewood over. The point is, if we remove cottage industry, it restricts our ordinance as it is today. It's undeniable, and there's no doubt. Yes, you say it clouds it. It does, because it doesn't make the issue cut and dry like a lot of people want to see, cut and dry my way. And I say, let's get uncut and dry to what the people need for their needs. Nobody's going to open up a Walmart on the property. And that's really what we're discussing here, having a ridiculous sized business here. Nobody's doing that in this town. Nobody ever has, and probably never will. And we'd probably have to deal with a Dunkin' Donuts if somebody decided to put one next to Godadero's house or something at that time. However, it is a goods or a service. I was denied, and I could have won that if I wanted to spend a couple of grand and go to court over it. The point is, I don't see why we should restrict people, and we are going to if we take cottage industry out. It absolutely restricts our ordinance as it stands now if we just go to home-based business. Because whoever the selectmen are at the time, whatever power base runs this town, can, at that moment, on a whim, decide what a home-based business is acceptable and which one isn't. And I'm not buying that under any circumstances. I'm sorry. Cliff?
10 years, 8 years.
Businesses that are run on properties that aren't adjacent to a resident and where the owner of the property doesn't actually live on the property have been going on in Brookfield for quite some time. Just one example is right up on Stoneham Road. Ben Bean owns a farm up there. He has some pet cattle. He's not making, it's not a working farm. He has a couple of pet cattle that he'll never slaughter. They'll never become burger. He runs a sawmill up there. And he charges people to cut wood up there. He also runs a scrapyard up there, which is, or was running a scrapyard up there, which is out of compliance with our zoning, and the Board of Selectmen did address it a few years ago, and I don't believe it still needs a lot of cleanup, but that's a work in progress, my understanding is. There have been other properties that have been utilized for business within the town of Brookfield. There was a lot up here on, no, it was down here on Governor's Road that was utilized for firewood a long time ago. So there's a history of properties within the town where the residents didn't actually live on the properties, having a business there and operating it within the town limits. I understand protecting the citizens' rights to privacy and to comfort and peace and noise. I do. But I also believe in the right and the freedoms of earning a living on one's own property where that person pays taxes. And if the biggest concern is that we're afraid that some outside source is going to come in and buy a piece of property and not live in the town of Brookfield and run a business on it, then maybe that's what we should look at is just add the words, must be a resident of Brookfield, without further restricting and requiring that the piece of property abut one's property where they reside. And I will argue, the definitions on what is cottage industry, what is a home-based business, what is a home occupation. For a long time, because they are different Webster defines them as different. And 2 years ago, it was a very, very hot topic at the meetings. So we've been down this road once before. It got tabled once before. And I think it should be tabled now instead of trying to rush something to make a March deadline where we can make hasty decisions and make mistakes that affect people's prosperity and lives.
Motion.
Oh, that was a comment.
Oh, comment.
Are there any more comments? Oh, I'm sorry, Rob.
I'm confused by how you can interpret the current zoning that allows customary home occupations to interpret that to allow a business that's not associated at all with a home. I do not understand how that interpretation makes any sense. And that, I'm not disputing that.
It's being addressed to me, so I can answer.
No, it was addressed to the chair.
I know, but it was in response to my comments.
If you'd like to reply, please go
I would. Because the way that has been interpreted all these years hasn't been the way that you've been interpreting it. Customary home occupations such as a... I don't have it in front of me to quote.
It's right here and...
Customary home occupations since offices of recognized professions, comma. That ends right there. Then it starts up with tradespersons, comma. That I'm just telling you, this is the way that it's been interpreted for years, Rob.
But that's not English.
I'm not disputing that. I'm just telling you how it's been interpreted.
Okay, so
And cottage industry is a separate issue.
Let him finish.
Cottage industries is a separate issue, and bed and breakfasts have been a separate issue. Okay, that's how it's been interpreted. Not that it's right or wrong, but that's how it's been interpreted all these years, and that's how all this stuff has been allowed to go on in the town of Brookfield. And it's not until years later, where different ways of thinking have come into play, that have questioned this. You can go back through some of the changes that have been made in this document over the years and scratch your head at the original way that they were written, because they make no sense. But they were written that way. One of the biggest things that they did was add the words garden activities into the agricultural issue in town in the old zoning. We're going to restrict garden activities? You can't plant flowers underneath your window? Because that's a garden activity. You can't sit back and go back, because we don't have a video library to listen to what they were thinking or see what they were doing back then. We just have to assume they did the best that they could back then. And I'm telling you that this is how that was interpreted all these years. And now, because we have a whole different way of thinking and legal ways of looking at things, we question whether or not that's proper English or it's not proper English. And because it's not proper English, you interpret it one way, where the town has interpreted a different way all these years. So if we need to clarify that, then we need to clarify it. But you can't remove those. I could not stand by and have those industries removed just under clarification, because they are not all encompassed by home occupations.
Before you respond, I just want to stop things for a second and ask Ernie a question. Now, Ernie, you were on the board in the early 80s, right? The planning board. Thank you. Can you give us some historical perspective as to how this has been? You've been a selectman, chair of the selectmen a couple of times, I believe. Is that correct? I mean, as the enforcement agency. You've also been on the planning board several decades ago, so you probably have seen this develop over several decades. I mean, from your perspective as a resident and participant in this, I mean, how has this changed? Has it been interpreted differently over the years? Has it been enforced differently over the years? Has it even been an issue?
I don't think it's been interpreted differently. I think there have been more challenges to the legal interpretation. In other words, it used to be fairly black and white, and now we're getting down to the more fine gray areas of interpretation, where the selectmen almost in every case now, unfortunately, we have to go out and get legal counsel to be sure that what we're thinking is in fact backed up by the law. And so we use legal counsel more than we ever did before.
Is that just, you feel, a sign of the times, or is that...
I think that's part of the sign of the times. But the town has always been, if they write a policy, they back it up. I'll give you a quick example. We had somebody come into the planning board and they said, we want to do this 21 lot subdivision. We said, fine. We said, but you have to build the road all the way through to town standards and it has to be accepted. And once it's accepted, then we'll issue building permits on the lots. A year and a half later, the builder comes and says, I want to do 1,000 feet of road. I'll sell these lots and then I'll build the rest of the road as we go along. And we said, no, you got to build the whole road because that's what the rule in the town is. And we went to court on that. We won. Because a lot of effort has gone into writing these rules. We do know what's in them. This home occupation is very critical. I'm just very reluctant to have dual standards, and that's kind of what we're talking about here. If somebody owns land and pays taxes on it, even if they don't have a concert here, back when that was a big controversy, I backed the property owner the first time because he owned land, he was paying taxes. But when the selectmen told him he had to close at 11 o'clock and he didn't, and they asked him why, he said, well, I didn't watch. He wasn't being responsible. Therefore, the town said, yeah, you had a chance, and they shut him down. And I'm sorry, I'm going to...
Okay. Eddie? please go ahead.
I just sitting here thinking 100 years ago, all the mills that were in this town that were not on residences. And I know times have changed. It's just all these things, and because I'm a big person on freedoms, but I mean, there were cider mills, tanning mills, shingle mills, sawmills, grist mills, all over this town. And they weren't always right next to the house or on that property. It's too bad they wouldn't allow you to have more mills, but that's just
Okay.
a little rabbit trail.
We have kicked this thing significantly.
Would you clarify for me?
Yes, please go ahead.
What this question is about? You should do that.
Well, here's what the rules say. Let's just review. The board shall deliberate to see whether it wants to incorporate the public comments or adopt the document or amendments. So right now we are discussing what has been proposed, kicking it around, kicking and kicking and kicking,
Gnawing on it, chewing on it.
and deciding if we want to vote to adopt the document or the amendments as a whole or in part. And I was just about to suggest, Brittany, that we've gone around and around on this. And if somebody wants to make a motion one way or the other, whether to continue this on as a working document outside the hearing structure, or to let me finish. Or to move forward and bring it as an amendment to the people at the March meeting, we can vote for that. Or I think there's a faction in this room that would like to table this, and if they wish to make a motion, they can make a motion. So if no one has any further discussion or deliberation on this issue, please. Anybody want to make a motion? Yes.
I'd like to move that we continue work on this. And I'll tell you why instead of tabling it, because things that get tabled tend to come back and rear their ugly heads again. I think if we make a motion to continue working on this, we might arrive at a consensus. And again, we might not. I don't think we're going to make the March meeting, because I think there's some pretty rough ground. See, to me, it's a matter of liberty. There's people that see it one way and people that see it another way. Some people see that the individual's liberty is a little more justified than the liberties or rule of the collective. Well, that's one of those arbitrary things that we're all fighting about in this country all the time anyway.
Would you like to make a motion?
I would. In the motion, and I already made the motion. I made the motion that we move forward with this and work on it.
As a working document.
As a working document.
Okay.
I second.
On down the road.
Okay, there's a second. Any discussion? If we move forward with this as a working document, it will not go to a second hearing.